if I could ask you to come in the auditorium and take your seats. If we could try to get everyone in from the hallway and take your seats, please. Bobby, as you're coming in, would you see if you could get folks in from the hallway? Thank you. Our last panel of the day, the third of the conference, which is following a kind of a logical sequence, if you figured out my method for putting this conference together, starts us into some more domestic issues. And starting with this panel and then following on with all the panels of tomorrow, we're going to be discussing several of the topical issues that you have been reading about in the newspaper, and of which lawyers and policy analysts scratch their head. The first one is one that should be no stranger to you. We've entitled it Domestic Spying. And obviously there are many ramifications of this issue, the NSA surveillance program and other methods of surveillance. And I'm delighted to turn the podium over to our panelist chair, Professor Neil Kinkopf from Georgia State University. So Neil, over to you.
Thank you, Scott. Let's see, we are not going to take over the podium for this panel. We've decided to be a little more sedentary and to remain seated. Our topic, as Scott mentioned, is domestic spying, and I don't think we're going to actually even get a chance to answer the question that's probably burning for each of you, which is how would improved domestic spying have eliminated the lacrosse team problem? Right? Instead, we'll talk more about that issue in the context of this conference. And to talk about domestic spying, we have a really distinguished panel that I'm happy to be getting to sit up here with. First, immediately to my left, well known here in these precincts, is Professor Christopher Schroeder, who is the Murphy Professor of Law at Duke's Law School. Professor Schroeder is one of the finest attorneys I've ever had the privilege to know. I had the chance to work for him at the Justice Department's Office of Legal Counsel. He is a brilliant lawyer, and in addition to being a brilliant lawyer, he's capable of communicating very difficult, complicated legal principles with clarity so that even those uninitiated in the complexity of the law can understand them. Chris has, in addition to heading the Office of Legal Counsel during the Clinton administration, has served as chief counsel on the Senate Judiciary Committee, and so brings a two-handed approach, an ambidextrous view of our legal institutions, our governing institutions. To Chris's left, we have Mary DeRosa, who is a fellow as Senior Fellow at the Center for Strategic and International Studies. Mary is Senior Fellow in the Technology and Public Policy Program. She was previously Special Assistant to the President and General Counsel on the National Security Council, also during the Clinton administration. She is now a member of the Department of Homeland Security's Data Privacy and Integrity Advisory Committee, the Advisory Committee to the ABA's Standing Committee on Law and National Security, and the Markle Foundation Task Force on National Security in the Information Age. To Mary's left is Professor Bill Banks from Syracuse University. Professor Banks is a chaired professor of both law and public administration in the law school and in Syracuse's Maxwell School. He is, in addition, the director of the Institute for National Security and Counterterrorism, and has published quite a number of books, including a book on the law of national security, which is out at the registration table, and a book that, and also is co-author of a book that I have found indispensable and that is never more than 5 feet away from me in my office, National Security and the Power of the Purse. To Professor Banks's left is Professor Michael Lewis. Professor Lewis is an assistant professor at Ohio Northern University. After starting his career as fellow rugby teammate of our keynote speaker, Prince Zaid, Professor Lewis went on to fly F-14s in Operation Desert Shield and was part of the strike planning team for Operation Desert Storm. After a distinguished career in the military, Professor Lewis went on to Harvard Law School and then on to practice with Booth Battle McGuire in Virginia, and then into teaching, where his young but promising career has already produced a number of articles in the area of national security law. So it's a very distinguished panel, and I will turn it over to them. Our first speaker will be Professor Bill Banks, who will give us kind of an introduction and then some more analytical comments. Bill.
Thank you, Neil, and thanks to Duke University for inviting me back. It's nice to be here. I do want to say, in light of Neil's comment about one of my books, that he should meet my mother. They could converse, the only two people I know of to have read that old title. That's very gracious of you. One of the most useful tools available to the government to learn about terrorist plans before they mature has been the Foreign Intelligence Surveillance Act, FISA. Whether the strategy is to arrest targets of surveillance early, or to continue monitoring in the hopes that more serious and sophisticated terrorists might enlist others as decoys or assets in a more concrete and more operational plot, FISA permits the government to keep tabs on the targets without their ever knowing about the surveillance. Enacted in 1978, FISA resulted from an interbranch compromise. Until then, no president had ever conceded that Congress could interpose any set of procedures to confine the constitutional discretion of the president to engage in electronic surveillance to protect national security. However, beginning in the 1960s, as most of you know, the Supreme Court had recognized an emerging constitutional right of privacy that's implicated when government conducts electronic surveillance, and courts soon began to limit warrantless electronic surveillance. Soon after that, the Watergate scandal and follow-on investigations of surveillance abuses by the Nixon administration and the administrations of earlier presidents emboldened Congress and eventually persuaded the president to go along with legislation that would cabin the president's discretion to conduct surveillance without warrant. 5 years after the September 11 attacks, now going on 6 years, it's my view that FISA has unraveled following amendments to the statute made at the insistence of the executive branch. A series of events led to this state of affairs. For one, September 11 itself created an aura of emergency in the government, and the emergency and its politics determined a range of policy and law developments. Congress essentially ceded its role in crafting legislation and in national leadership, while the executive branch seized the initiative to fight the global war on terrorism at home and abroad with the tools it could fashion. With a few notable exceptions, the courts have been sensitized to the emergency. At the same time, a few weeks after September 11, Congress enacted the USA Patriot Act. Some FBI guidelines were rewritten, both of which modernized the law for accounting for new technologies and changing tactics in the never-ending leapfrog of technologies of detection and evasion. Despite the administration's proclaimed satisfaction with these new tools, they instead circumvented the updated FISA procedures in secret in undertaking a new domestic surveillance program through the National Security Agency, or NSA, the Terrorist Surveillance Program. On December 11, 2005, the New York Times revealed what the administration later called the TSP, or Terrorist Surveillance Program, when it reported that President Bush had secretly authorized the NSA to eavesdrop on Americans and others inside the United States to search for evidence of terrorist activity without judicial approval. In a letter from the Justice Department to the Congressional Intelligence Committees a few days later, the Assistant Attorney General stated that a secret order from the President had authorized the program shortly after September 11, and that the surveillance aimed there is at, quote, certain international communications into and out of the United States of people linked to al-Qaeda or an affiliated terrorist organization, end quote. Since beginning the program, NSA is monitoring the telephone and email communications of thousands of persons inside the United States, where one end of the communication is outside the United States without warrant. Aside from defending the program as crucial to our national security, the President lamented the unauthorized disclosure of the effort, revealing classified information President Bush said is illegal, it alerts our enemies, and endangers our country. The Justice Department launched an investigation of the leak, and many of us then wondered how the President could have stated even in 2004 and 2005 that, quote, anytime you hear the President, or excuse me, the United States government talking about a wiretap, it requires a court order. Nothing has changed. When we're talking about chasing down terrorists, we're talking about getting a court order before we do so. Now, this law I mentioned a moment ago, the Foreign Intelligence Surveillance Act, was obviously available for that purpose and had been utilized to obtain foreign intelligence surveillance orders in secret for many years, since 1978. The administration initially defended its decision not to rely on FISA processes. Given the expansiveness of the definition of electronic surveillance inside the statute, and some provisions inside FISA which make it exclusive, and a companion statute which criminalizes utilizing other procedures for electronic surveillance outside the statute, the administration, I think, early on faced an uphill legal climb. FISA provides criminal penalties for anyone who engages in surveillance, quote, not authorized by statute. The administration argued early on that the AUMF, the authorization for the use of military force, enacted a few days after 9/11, constitutes the necessary authorization within the meaning of that language from FISA. However, it's fairly clear from the text and history of the FISA provision that the purpose of that exception, that exclusivity and criminal sanctions provision, was to provide security to intelligence personnel who act in accordance with FISA, not to immunize them if they violate the law. Attorney General Gonzalez emphasized early on the need for speed and agility in making judgments about particular intercepts. And he maintained that navigating through FISA would delay the work and produce what he called critical holes in our early warning system. Acknowledging the emergency authorizations that were expressly contemplated in FISA, where indeed the government need not seek prior authorization and only must go to the court within 72 hours of launching surveillance, the Attorney General implied that the required procedures were too burdensome, or that perhaps they could not be met. He noted that he would have to sign off on each application, as would the lawyers at NSA and Justice, and after determining that all provisions of FISA have been satisfied. Although the Attorney General did not state whether it was the anticipated failure to meet a probable cause requirement in FISA or the burden of meeting the 72-hour deadline that led the administration to go outside FISA, then Deputy Director of National Intelligence General Michael Hayden stated at about the same time that the administration had unilaterally adopted instead a reasonable suspicion standard in applying the TSP because the probable cause standard in FISA was, in the words of a commentator, quote, too onerous. The administration did pass up some earlier invitations to review and perhaps revise the probable cause standard in FISA. I won't bother to describe those now. We could later if you'd like. Attorney General Gonzalez asserted that anytime during the period of 2002 through the revelation in December of 2005, that any time they had sought or appeared to seek legislative authority for the TSP, they would have tipped off the enemy and let them know what surveillance activities we were pursuing. Although Gonzalez stated that the administration had been advised that it would be difficult, if not impossible, to obtain such an amendment to FISA, he apparently referred not to the political or legal difficulties such a proposal would face, but to the concern that that amendment could not be obtained without jeopardizing the existence of the program. He feared, for example, that once the administration admitted that the program existed and cautioned that the program only intercepted international calls, in theory, those who were subject to surveillance could evade the program through countermeasures, such as the use of voice over internet protocol VoIP phones with US numbers, but used abroad. There is an intelligence oversight dimension to this affair during 2005 and 6, actually since late 2001, that I'll leave for my colleagues to describe, concerning the extent to which Congress was appropriately aware, fully and currently informed in the language of the law of the TSP and its contours. Those who instead characterize the TSP as a complex and technologically advanced data mining program that simply cannot be fitted inside the obsolete structure of FISA take a different path toward characterizing its lawfulness. Apart from the Attorney General and the President falling back on the need for speed and agility, stating that the war that we're engaged in now is a different war, some advocates of the TSP say quite simply that the laws fail to keep up with technology. According to General Hayden, however, who was head of NSA when the program was implemented, TSP, now I'll quote General Hayden for a moment, is not a drift net over Dearborn or Lackawanna or Fremont, grabbing conversations that we then sort out by alleged keyword searches or data mining tools. This is targeted and focused. That was General Hayden. He claimed that the surveillance was limited, again I'll quote him, to international calls and only those we have a reasonable basis to believe involve Al-Qaeda or one of its affiliates. He was blunt. We're not there sucking up comms and then using some of these magically alleged keyword searches. Did he say jihad? End of quote from Hayden. Instead, as General Hayden said, a shift supervisor at NSA headquarters substitutes for a federal judge. She decides what part of the product of the data mining merits further targeted surveillance, and the standard she employs in making these decisions is reasonable suspicion instead of probable cause. With that introduction, why don't I stop there and save remaining comments for the Q&A.
Hi. Thanks very much to Duke and to Lenz. I'm very happy to be here. I realized at some point that I'm the only person on this panel who's not a law professor, which I find a little intimidating, but I've decided to focus my comments sort of more on policy and governance issues and also to step back a little and not address specifically the FISA TSP issues, but talk more generally about domestic intelligence and what I see as a sort of state of denial, both within the executive branch and outside, about the changed need for domestic intelligence and what that means. and when I say within the executive branch and outside, I mean certainly within the executive branch you hear a lot about when in defending particular programs when they come out, about the need, and the TSP would be an example, about the need for greater domestic intelligence and how if we don't do this, we'll be more likely to be attacked. But I think what you don't hear is they're sort of schizophrenic about it, because what you don't hear is an acknowledgement that a greater need for domestic intelligence. And I'll pause for a second and say, and I think Chris Schroeder is going to talk a little more about this, about why we need domestic intelligence more with the terrorist threat, a threat that is more domestic, located more domestically, and for which we need more fluid access to information. But although the national security community appears to understand that, they don't acknowledge that there is any need for a change to roles of to decision making, to laws other than privacy oversight and privacy protections other than to make them less restrictive, and in different approvals. As an example, I was not there, but reportedly Ambassador Negroponte, when he was DNI, was speaking at an event, and someone asked him about the role of the DNI's office in domestic intelligence, and his response was, "We don't do that, that's the FBI." And I think that response reflects a discomfort in the intelligence community, which is used to looking outside and being foreign-focused, about a role in the domestic intelligence. But it's a troubling comment, because it is not just the FBI that is involved in domestic intelligence collection, and if there is, it reflects a certain denial. You also see this denial when you hear relatively frequent when the administration is talking about how they will address privacy with the use of domestic information for intelligence, and they say, "We will follow privacy laws, we will follow the laws." Unfortunately, the laws really don't say much about what they can and cannot do in the areas we're talking about, in terms of use of domestic collection of information from data aggregators, data mining. There really is not much that is, the privacy laws that we're familiar with, Privacy Act and others, were from a different time, address a different situation, and don't provide a lot of restriction. So saying they'll follow the privacy laws is really like saying nothing at all. And I don't mean to suggest that they're out trying to break the laws. All I mean is that it doesn't acknowledge that we are in a changed situation with respect to the need for and the use of domestic intelligence. The privacy community and others, on the other hand, are deeply suspicious of any attempt by the national security community, the executive branch, to use information, domestic information, in new ways, in innovative ways, and with every leak of a new program, the TSP being one example, but there have been others. This suspicion grows because there is a sense that there is a lack of accountability, a lack of any restriction or oversight. So if the privacy community, if the executive branch were in fact to say, okay, now we're going to take a whole new systematic look at how we deal with domestic information, I think that there probably from the privacy community would be a big uproar and a great deal of mistrust. So we end up sort of not going anywhere, and what you have is programs to collect domestic information for intelligence purposes do happen, but they don't happen, they happen ad hoc, they don't happen with any systematic guidance, coordination, And they also, because they're ad hoc, there are things that almost certainly are being missed. And you hear people in the intelligence community concerned that there might be information that is being followed by an intelligence agency overseas, but when it comes to the United States, or when an actor or somehow the information becomes domestic, they stop and nobody else picks it up, or at least there's no coordination of following that information, and that's in general terms a concern that you hear fairly frequently. And this is, I think, another the other result of a lack of any real tackling of the domestic intelligence, the new paradigm or the changes to the need for domestic intelligence. So programs get leaked when they happen, mistakes are made, distrust grows, and you end up in this same cycle, and nothing really seems to improve. So I guess I would have a couple of comments about what I think needs to happen, and I think primarily in the executive branch, the responsibility rests with the DNI. The DNI has got to take this on, difficult as it is, to step up. Not a natural role for the intelligence community, as I said, but that it is part of the role that was contemplated for the DNI to coordinate and be responsible for domestic intelligence. And when I say domestic intelligence, I mean domestically collected foreign intelligence. First, the DNI needs to get a handle on what is going on. I doubt there is any person who knows really what kind of programs there are collecting domestic information in the Department of Defense, in the Department of Homeland Security, in any number of agencies that feel that it is part of what their mission is to collect this information, or that they are furthering their own mission, and it is something that they need to do. Somebody needs to get a handle on that. Very importantly, define the roles and missions of the different agencies and entities in collection of domestic intelligence. Yes, FBI has the primary role, but FBI does not have the only role. And if you say that that's FBI's job, then you are ignoring the fact that Department of Defense, for example, it's got some responsibilities in the domestic area. What are they? What are they not? And how can you set out standards for when they can and cannot, or should not collect this information? Department of Homeland Security obviously has responsibilities to collect some domestic information, but what are they, and when should they be doing it, and when shouldn't they? NSA, CIA. Does CIA have any role and mission in collecting domestic intelligence? That's a question that somebody needs to answer. So I think, and then tasking and coordinating. If other agencies have a need sometimes for domestic information to further their mission, but have no responsibility to, have no authority to collect it, they're going to need it. And somebody's going to have to be responsible for coordinating so that they get it, or they'll go out and collect it themselves. Guidelines and rules for what we can collect and how, I think that's critical. There has been some effort on the part of the executive branch, but we're still in a very, very early stages of really defining what can agencies do with domestic information and what can they not. And critically, and this is, I think, the recent disaster with national security letters makes it very clear that there needs to be process for oversight, for auditing, for compliance, to make sure that rules are being followed. You cannot rely, and I don't mean to say this because you cannot rely on executive branch employees or any employee to police themselves entirely. It's not their job. It's not because they're bad. It's because they're human. It's not going to happen. And so to have some mechanism for audit, monitoring, compliance programs, periodic reviews, technology tools, there are a lot of judicial checks in some cases, and that has to be systematically addressed. And I will will only say that I wish that every time somebody talked about domestic intelligence, you didn't hear about MI5, because although an interesting issue, it is, in my view, a side issue. All of these other questions that need to be addressed first, and I apologize if I went over my time. I will now turn it over to you.
Thank you. I'm going to pick up on a theme that I'm going to describe as the theme of the fact that we live in an information-deprived environment with respect to understanding the surveillance problem, and relate that to the conference theme of trying to figure out a way forward from here. It's become a platitude, I think, to say that 9/11 changed everything. But with respect to the problems of domestic surveillance, I want to argue that you can actually describe more precisely the way in which 9/11 changed our approach to domestic surveillance. And I want to give you that description in just a moment. But while you're anticipating it, I want to first emphasize that the task of balancing the relationship between national security and civil liberties in this environment is something that we're still very much working on, even though we're running up towards the 6th anniversary of that event. It's still a work in progress. And one thing that affects the balance is going to be the public's attitude toward the situation. And one thing that affects the public attitude is whether the current news cycle is running stories about some terrorist cell at the FBI has rolled up in advance of and thwarted some attack, or some attack that's been planned on LAX that has been intercepted, versus running stories about warrantless surveillance programs and national security letter abuses and New York police traveling around the world to surveil dissident groups in advance of the Republican National Convention. You only have to look at the history of the Patriot Reauthorization Act to see the effect of the news cycle. That act was proceeding through Congress without a whole lot of controversy, some controversy, but it looked like it was going to pass in a form that was pretty acceptable to the administration. But then in December 16, 2005, the New York Times broke the warrantless surveillance program story in the front pages. And even though there was nothing in the Patriot Act that had anything directly to do with the NSA program, it changed the political dynamics of the reauthorization event substantially. It encouraged enough senators to filibuster the bill that it was prolonged until March, when the sunset date was December 31st. Concessions were eventually given that resulted in some greater civil liberties protections being written into the final bill. So stories relating to the nature of the surveillance, when they come in the form of leaks and ad hoc stories, are going to affect the environment one way or the other. And they've been accumulating, these stories. Item, the national security letters story in March, when the Washington Post had a year earlier published a story suggesting that maybe national security letters were being used at the rate of something like 30,000 a year, which was an extraordinarily high number post 9/11. Then the Inspector General reported that in fact the number in calendar year 2004 was 60,000 a year, and that 22% of the files that had been investigated by the Inspector General in a random sample had some deficiency or irregularity in them. Item, for at least a year prior to the 2004 Republican National Convention, teams of undercover New York City police traveled around the world, throughout the country, to conduct covert observations of people who planned to protest at the convention. From Albuquerque to Montreal, from San Francisco to Miami, undercover police attended meetings of political groups posing as sympathizers or fellow activists. Item, warrantless surveillance, which we've discussed, and an extensive data mining of the cooperating telecom companies that undoubtedly accompanies the intercepts. Item, even though the NSA warrantless surveillance is an end run around FISA, the number of FISA warrants has more than doubled pre-9/11 and post-9/11, from something like 900 in the year 2000 to something like 2,100 in the year 2005. So with that kind of stage setting, let me give you the description of the post-9/11 surveillance environment. You can grasp the central element of what I have in mind through a conversation that Bob Woodward recounts in his book, Bush at War. And he recounts an early meeting closely after 9/11 in the National Security Council, in which the FBI director, Bob Mueller, raised the need to take care that people should take care that evidence of possible second attacks that was being feverishly gathered throughout the government by law enforcement ought not to be tainted in the event of subsequent arrests and so that subsequent arrests and prosecutions could be successful. This supposedly, according to Woodward's report, prompted the Attorney General to interrupt and say, let's stop the discussion right here. The chief mission of law enforcement, Ashcroft said, is to stop another attack and apprehend any accomplices or terrorists before they hit us again. If we can't bring them to trial, so be it. So, post 9/11, we went into what the Attorney General and the President have described as a mode of prevention first. Now, when you combine the mode of prevention first with an understanding of the nature of the threat, you get some predictable results. What's the nature of the threat? Well, it's simply that we're trying to protect ourselves from people who are currently unknown to us. In order to search for useful information that can lead you to the identification of these people, you need to throw a net over a very wide circle of people. Once you find a potentially suspicious person, you can engage in more targeted surveillance. Even then, however, if you're really interested in prevention, you probably need to drop the cutoff point for how much evidence you need in order to be able to justify that targeted surveillance. See the move from probable cause to reasonable suspicion. As the President has said many times, prevention means it is better to be safe than sorry. Now, this strategy is completely rational. It also has some predictable consequences, and I want to just mention 3 of them. First, it will produce a lot of false positives, which will mean a lot of people are being surveilled who turn out to be entirely innocent. Second, it will produce abuses. Any legal authority gets misused some of the time, and these authorities will be too. Third, the strategy will result in surveilling people who are engaged in protected First Amendment activities, like free speech and public assembly. That's because it's also rational to assume that groups that are hostile to the United States or its policies are groups where you just might look to spot people who support terrorists, or even to spot terrorists themselves, who just might, after all, frequent such groups in order to identify potential recruits for their cause. A good time to surveil members of such groups is when they congregate, and when such groups congregate, they engage in a lot of First Amendment protected activity, like free speech and public assembly. So we live in a surveillance environment that will produce false positives, that will produce abuses of authority, and that will at least impinge, if not sometimes even violate, free speech rights. These are prices that we pay for being in a post-9/11 world. They may be prices worth paying. I suppose I've sounded critical of current surveillance practices so far, but I'm actually simply trying to be descriptive, to paint a picture with a broad brush to illuminate the nature of the costs that need to be weighed. Of course, they need to be weighed against the benefits. And here the questions are not the simplistic ones, such as has there been another attack, or have individuals been arrested, tried, and convicted for terrorist-related offenses. The questions ought to be ones that examine particular practices and ask whether there have been sufficient marginal gains from these particular practices to offset their costs. Oftentimes, I think the result of such an analysis is not going to be either to categorically approve the practice or to categorically condemn and jettison it. Such analysis might suggest ways to continue the practice, but with additional safeguards to mitigate the costs. That's what happened illustratively in the case of several of the Patriot Act reauthorization provisions that were revised after the NSA surveillance story broke. The national security letter provisions weren't gutted from the act, but additional procedural safeguards were included. We can debate how adequate they were, but that was the nature of the compromise that was eventually reached. So the bottom line point is simply this: a prevention-first strategy to fight against the next terrorist attack will predictably produce certain pathologies, and these pathologies need to be evaluated against the benefits. Now that evaluation requires information. To date, we have been living largely in an information-deprived environment.
But without information, people can only form opinions based on their prejudices and fears. The administration's response to requests for information is uniformly the same. Trust me, says the president. Lawyers have looked at these programs, and the American people can be assured that the government is abiding by the rule of law. Some people accept that, but increasingly people don't. And pure trust, I submit, is just implausible. The pathologies of a prevention-first strategy are all too predictable. That does not mean that prevention first should be abandoned, but it does mean that we need to have an informed conversation about the balance between civil liberties and national security in an information-deprived environment that just can't occur.
Thanks. In 1929, Henry Stimson, then Secretary of State, rather famously said that gentlemen don't read each other's mail. And he said that on the occasion of disbanding the only cryptanalytic function that the government had at that time. Fortunately, 2 years later, he reversed himself. He didn't explain whether it was that perhaps foreign policy was no longer the province of gentlemen, or if perhaps gentlemen's behavior was different from what he thought it was in 1929. But for either reason, we ended up having cryptanalytic capabilities that were crucial in winning World War II. They were crucial to winning the Battle of Midway because we were able to break the Japanese code, crucial to our successes in Europe when, along with the British, we used the ultra-intercepts and that sort of thing to help us beat the Germans. And similarly, throughout the Cold War, you had NSA doing surveillance not only overseas, but also domestically, of people who were talking to the Soviet embassy, being run out of the Soviet embassy, and intercepting those communications. It wasn't until FISA came along in 1978 that there was any challenge or question about the executive's ability to do this sort of thing, or perhaps the benefits that came from that. But in 1978, it has been well laid out. Things changed. FISA came in, and because of the privacy concerns that the Supreme Court had expanded over that period of time, as well as Congress's own reactions, we then started living in the FISA environment. Now, the other point that Professor Schroeder made is that we are now, post 9/11, living in an era of prevention rather than prosecution. And for prevention, the greatest tool that you have, of course, is surveillance for the reasons that he gave. The important part of surveillance, of course, is that the person being surveilled must not know that they are being surveilled. That's just the most basic part of that equation. And the difficulty then with the conclusion that we are in an information-starved environment, that we need to have a robust public debate about the prices and the payments and the types of information we are going to gather and how we're going to gather it. The call for an intense public debate, by its definition, defeats the value of any kind of program you end up approving. And that is the quandary we are in. The question is, how do you go forward from here and deal with that Hobson's choice of, do we go ahead and trust a government to not impinge on our civil liberties any more than they already have, especially when there may be indications that they have been willing to do so beyond what some people are comfortable with? On the other hand, if we have to have this public debate, is the public debate going to destroy the whole purpose of the surveillance in the first place? Now, one of the questions would be, is FISA as it stands now the answer? And I think that Mary had talked a little bit about some of the things that she feels are important with regards to people understanding what they need, people understanding how they need to divvy up responsibilities, take responsibilities for certain aspects of domestic surveillance. And it's important to understand that when we talk about domestic surveillance, we are not talking about surveillance that is purely within this country. Even as things stand now, what you are talking about is surveilling someone in the United States that is talking to someone overseas, and that someone on either end of that conversation, one of those two people has to be sort of articulable suspicion standard, a member of, sympathizer with, or supporter of Al-Qaeda or other terrorist organizations that mean to do us harm. And so it is not, when I hear the term domestic surveillance or domestic spying, I think more of the idea, perhaps, of communications between two individuals in Durham and Charlotte or something like that. And that is not what is going on even under the current administration at the current time. But with regard to who is doing what, I don't have any specific information. I'm not privy to that sort of thing any more than any of you would be. But it would seem that NSA has figured out who is doing what in terms of the surveillance. They've been conducting this since 2001 or 2002. They have established their rules for who they surveil and who they don't. It has to be, as I say, one of the terminals has to be overseas, and there has to be whatever the standard is, whether you want to call it articulable suspicion or reasonable belief, that one of those terminals is an al-Qaeda member, supporter, sympathizer. So I think that there is at least some sense that some of the government knows what it's doing. Yesterday or the day before, Mike McConnell, the National Intelligence Director, actually came out with his requests for expansion or changes in FISA. He specifically said that what he needs after talking to NSA, CIA, the defense intelligence agencies, and other groups like that are all under his purview, what we need, or what he says he needs, is an extension of the 72-hour rule to a week, which is basically saying that we are allowed right now under FISA to begin surveillance, and we can have 72 hours until we get judicial approval from a FISA judge saying this is okay, you can continue. If you can't get that done in 72 hours, you have to turn it off. And what he's saying is we need this to be a week because of, they've talked already a little bit about some of the procedural difficulties, the number of sign-offs you have to get, who you have to get to sign off, when, how. You have to find a judge who's available at that time to do that. And while I'm aware that FISA judges are incredibly available at all kinds of odd hours of the night and that sort of thing to go ahead and approve such warrants, it can still be a difficult task to get in under the 72-hour wire. And the need for continuity in intelligence is incredibly important. And so you don't want to have to turn this off for hour 73 and hope that you can pick it up on hour 96 once you've gotten the approval of the judge. So one of the things that NID McConnell is asking for is to extend the 72 hours to a week. Another thing that he is asking for along the same lines in terms of continuity is 120 days. Right now, once you get a warrant from the FISA court, it's good for 120 days. You can surveil that person in whatever means that you have talked about for that period of time. After that, you have to get the warrant reissued. And what he has asked for there is to take that from 120 days to a year for the same kinds of reasons in terms of the ability to reacquire or the need to reacquire and the need for continuity. And the last thing that he has asked for, and these are sort of a draft legislative proposal that he has floated in the last couple of days, is that this apply to U.S. citizens only. So that if we are talking about surveilling a foreigner in this country, that is not something that's going to require a warrant merely because they are located in this country, or merely because we're going to put the tap on at this end of the phone line as opposed to in Afghanistan or Iraq or wherever. And so those are the main proposals that the National Intelligence Director is saying he needs. And he also concedes, and I think anybody must concede at this point, to whatever extent we are going to make changes to FISA to allow these sort of things, there has to be a robust and healthy debate at this point about what should or should not be included and how these protections should be extended or not. I think that the one critical thing, though, for Congress, if we are going to change this, if we're going to have this robust debate, and quite honestly, this robust debate is going to be very detrimental in the short term for our intelligence, because in the short term, every single day, CNN or MSNBC or Fox News or whoever else is going to remind us that Congress is talking again about domestic intelligence or domestic spying or whatever you want to characterize it as, and they're going to remind everybody that, oh, by the way, if you're on a phone call overseas, you may be surveilled, or that if you're on an email traffic that is going overseas or whatever else, again, that may be surveilled. And so if you constantly remind people that they are being watched or could be watched, it is going to, in the short term, damage your intelligence collection. That's a price you have to pay because we have to get this right at this point. We have to figure out what boundaries we want to place on this and how we want to go forward. But the important thing that we have to include in whatever decision we come to at this point is a way to continue to monitor, change, and flexibly move these guidelines as needed in the future without an intense public debate. Because every time you make an intense public debate, you are harming their surveillance efforts. And the way that you have to do that is come up with a way to get people that you trust in the legislative branch to conduct oversight. I absolutely agree with what Mary's saying, that oversight is critical. You cannot trust, doesn't matter who you are, an executive of any kind to police itself uniformly. There will be, as Professor Schroeder has mentioned, abuses of power. There will be a greater number of false positives, and you have the First Amendment issues that he also talked about. Those are problems. And so you have to have the oversight, but what you have to do is find a way to decide who the oversight will be. Is it going to be the ranking members of both parties in the intelligence committees? Are you going to include the ranking members of the Judiciary Committee as well, perhaps? But it has to be a number of 5, 10, 20 people that you can trust to remain, I guess, keep it confidential and understand that their concerns can get transmitted and must be dealt with by the executive. And that's the other thing. If you're going to say to Congress, you cannot have 535 people debate this every time we need to change things, if we are going to limit this to 10 people for security reasons, you have to have some guarantee that the executive will act in response to the concerns of a majority, plurality, 30%, whatever number you want to use for that small group that you entrust to conduct the oversight. And the last thing before I pass this back off is I also want to emphasize the point that Professor Schroeder made about who wins this fight in terms of civil liberties versus sort of national security, if you want to look at it as a fight or a balancing test. Ultimately, if what you hear on CNN every day is about a new program that is infringing on people's rights, then the public support for any kind of program is going to diminish. If you are hearing about major successes and terrorist cells being rolled up, then the support goes up. The unfortunate thing is that this playing field is tilted very heavily against national security, because anyone that is a member of the national security infrastructure is very loath to talk about their successes, because by talking about their successes, they are preventing future successes. And they understand that, and they are not going to go about publicizing them unless they believe that there are no future successes to be had from that source. And as a result, I think the playing field is, as set up now, very, very strongly tilted against national security in that sense, because if you are truly interested in national security, you will not go out and publicize your successes, which means that what the public is going to hear is far more about the civil rights abuses that undoubtedly are going to occur at times when you run programs like these.
Great. Thank you, all the panelists, for those very helpful introductory remarks. Before turning it over to the audience for questions, though, I want to take the privilege of the chair and ask a few myself. And in particular, I'd like to start, Chris, by asking you to respond to Mike's challenge, which is that, your approach of kind of doing a rational cost-benefit analysis may make sense in lots of policy areas, but not this one, because we've got the Heisenberg uncertainty problem of observing something affecting it, right? So won't you actually end up killing the programs by examining them?
Yeah. Well, of course, there's something to that. And if you were going to debate in advance whether a particular suspect could be subjected to a particular surveillance device before it could be utilized, we'd be in total agreement. I remain pretty skeptical about the blanket argument that discussing at a programmatic level the desirability or the procedural safeguards for a particular surveillance technique destroys the usefulness of the technique. Criminals have known that the FBI has wiretap authority. They know that the FBI can look at emails. They know the FBI can acquire their financial records. That is, if they've looked at the U.S. Code or watched Law and Order. They know that. And yet those techniques continue to be useful. The NSA program, we still don't know the details of that program. There's lots of stuff on the internet about what the NSA technological capabilities are. There have been prior versions of data mining programs that the NSA has conducted that have been written about in books. James Risen, the fellow who broke the story in the Times, had published a book about the CIA and NSA technologies in advance of, a lot of that reporting had been done in advance of his particular reporting on the NSA surveillance program. So those don't tell you if you're a Al-Qaeda operative, those don't tell you the specifics of exactly the program that the NSA is running. But you've got to know, if you're as intelligent as we take the enemy to be, you've got to know that these technological capabilities exist, and if they exist, they're going to be utilized by the government. They're just too potent to be the province, the decisions using them to remain the province of a selected few. I mean, this is a constitutional democracy in the end, and it may be that for a limited period of time you pay a price in some costs, although I'm skeptical about how serious those costs are. But in the end, I think that's a price you have to pay. We've really undergone a sea change in our attitude toward what counts as appropriate and legitimate surveillance since 9/11 that we've only discussed piecemeal and without the benefit of a robust debate. We really didn't have that during the Patriot reauthorization, which got pretty fixated on whether the libraries were going to be protected and other vital interests were going to be protected. We need to have, there needs to be some social settlement about the issue of how much surveillance is going to be permitted in the context of understanding just how dramatic the increases have been. And I think you just have to have the information available to discuss that, or you can't do it intelligently.
I'd just like to add a little, really to echo what Chris said, but to, I mean, I think that we have to be a lot more nuanced about what can be discussed and what can't be discussed. Clearly, in a national security area, there is a problem with revealing information that could hurt the programs. But there is so much more, I think, that you can talk about than what we have been talking about. Processes, approvals, the way a program would work doesn't necessarily give away who you're going after. The covert action, I think, is an example of really one of the most sensitive areas you could possibly have. But the process for approval of covert actions is out there publicly. It doesn't hurt. So I think that we need to get away, and this is just to really to repeat and agree with you, to get away from these blanket statements about we can't talk about that because it's classified, because there is a great deal that we can talk about while keeping the most important things classified.
Paradigm of prevention, and indeed that's where we are. We need to talk about how you align that paradigm with the notion of individualized suspicion. To General Hayden was a wonderfully candid and very thoughtful man and an extraordinary public servant, and he in good faith said, I'm willing to trust a staff person at the NSA to make the judgment about reasonable suspicion before further inquiry is taken of one of these suspects. We need to have a broader debate outside of his office about whether that's an appropriate approach to questions like this.
Mike, did you want
The one thing I would agree, the idea of a social settlement is, I think, exactly what I am searching for. We have to have, at this point, a robust debate as to how things are going to go forward, because there are a lot of balls in the air and a lot of different things that have to be decided one way and another. One of the things that I'm asking for at the end of this, though, is some sense of closure, an ability to say, all right, we have had this debate. Here are the lines we are drawing now. And here are the ways that in the future we are going to try to make sure that that debate is less public. Hopefully not with less oversight. We can create oversight, though, I believe, that has at least a degree of robustness that will still allow for a lot less attention to the problem. Now, this sense that everybody knows what's going on is in some ways true and in some ways not true. I think, first of all, the people that you catch who don't watch Law and Order or don't read the U.S. Code and don't understand that they are being wiretapped are the more unsophisticated criminals, just as there are unsophisticated terrorists who don't watch CNN, don't have any idea that, in fact, if you're calling overseas, you may well be monitored now. And so, yes, we will still catch unsophisticated individuals. But I think that the idea, first of all, that they are not sophisticated. There are some that are not, and there's some that are. There's some that watch CNN. There's some that will understand what's going on and will understand what our capabilities are at any given time. But this is always a battle. In any kind of military situation, and that's what this is at some level, there is always offense versus defense, and there are always developments. There are things that today are reasonably secure that a year from now or 2 years from now, NSA will have made not secure any longer. And they don't need to know when that happens, and they don't need to know how that happens. And depending upon the way the debate is phrased, and depending upon what it is that you're talking about in Congress, that can come out. And if you tell 535 members of Congress anything, somebody outside of that 535, even if they are sworn to secrecy, is going to learn about it. Everybody knows that Congress as a whole cannot keep a secret. On the other hand, we've also seen that if you have 8 members of Congress who were informed of this whole NSA program from early 2002, they were consulted dozens of times during the NSA program. It wasn't until the New York Times broke it in late '05. So for 3 years, those 8 or whatever number of gentlemen did keep a secret. And that, I think, is how you want to look at things. Let's find a way that we can tweak these programs, allow new technology in, and figure out how we're going to cabin that new technology as we move along in a way that doesn't have to reveal its use to the enemy at that time.
Chris, I'd like to follow up with kind of a technical question that's not just for you, but also for Bill. Assuming Congress wants the kind of information you're talking about in order to do this inquiry, sort of technically, how will they get it? Because I would anticipate the administration taking the position that Mike has been taking, that simply revealing the information is itself going to jeopardize the effectiveness of these programs. We're not sharing this information with you. If you enact a law requiring the submission of reports, there are hundreds of signing statements saying those provisions are unconstitutional and will be abided with only sort of out of comity if the administration wants to. So that, what's the next step? How would Congress go about getting the information if it wants it? And Chris, either you or Bill, I know you've worked for Congress as well.
Well, they might not get it. If the administration doesn't want to give up information, it's awfully hard to get information out of the administration at the end of the day. Congress has its means. I mean, it doesn't have the rack and screw anymore. They've retired that, but or it doesn't have the jail in the basement of the Capitol where they used to put witnesses who appeared and wouldn't answer questions. You can subpoena the information. You can hold people in contempt. You can hold up appointments, approval of appointments. You can hold parts of budgets hostage. Congress has its leverage points. But I think the basic problem we've had, and I don't particularly want to bash President Bush because all presidents learn to hate Congress. It's an obstacle to anything you want to do if you're in the executive branch. It's a big bump in the road, and people there just get in your way. But it is a co-equal branch of government, and when the relationship works the best, it's when people on both sides are making good faith efforts to understand the needs of the other branch. And that works both ways. That means Congress has to have a genuine understanding of how important it is to keep methods secret. and not insist upon their disclosure. They have to be able to listen to those arguments coming out of the DNI's office or the Justice Department office or wherever it is, and they have to accommodate those interests. At the same time, you have to have people in the executive branch who will actually concede the legitimacy of a congressional inquiry and say, yes, I understand that you have a constitutional role as the elected representatives in a different branch to conduct oversight. And so the executive branch has to be more forthcoming in terms, well, let's work out a way for you to get the guts of the information you need or the framework that you need. I can't tell you this, this, and this, but I can tell you this, this, and this. So take a look at that, analyze it, see if that answers your question about the kind of improvements or changes you want to make in a law. That's the way the process ought to work. It doesn't all, it's very hard to get it to work that way, especially when you're in a system of divided government. Unfortunately, we have this kind of paradox in our country today. When we're in divided government, the two branches are at loggerheads with one another, and there's a lot of partisan politics that creates spark points and flashes. And we have a united government. The Congress becomes the lapdog of the president and doesn't conduct oversight. So it's a very unhealthy situation, and I don't have a solution to it.
Maybe build it.
There's a softball for you, right?
Yeah, it's a softball. I don't have a solution. With respect to the 8 and how the limited oversight occurred in the 3 years that Mike was pointing to, there does need to be some attention to the law if the program is to go forward and Congress is to play. As written, the so-called Gang of 8 may take the oversight responsibility only for covert operations. This was not a covert operation. This was an intelligence collection program. The law as written requires reporting to the full intelligence committees in the House and Senate for intelligence collection. That was admittedly, I think, was not done in this instance. Perhaps it should not have been done, but the law as written requires it to be done. We're going to have to go back and revisit that. I also think that with regard to the policy looking forward, not how to do the oversight so much, but how to structure the mechanism, McConnell has come forward with a proposal. There were several bills last year that, as many of you recall, just sort of died, as many do at the end of a session of Congress, particularly elections and all. There's some very controversial but thoughtful and detailed proposals there. They'll be fully aired. I'm sure they'll be fully aired. And somebody's going to have to wrestle to the ground this question of just how much discretion you want to give out front to the executive branch, and at the same time then think about the oversight mechanisms. One of the institutions we haven't talked much about is the FISA court itself. And it was, I wish I had been in the conversation there between the Department of Justice and the FISA and working out what President Bush characterized in January as some kind of an accommodation to allow the program to go forward within the context of the FISA mechanisms. Those judges who admittedly meet only in secret are Article III judges. The FISA job is moonlighting, and these are obviously life-tenured judges who are appointed by the President and confirmed by the Senate, so they're officials with whom we ought to have the highest trust and confidence. So it may be that some degree of the work here that needs to get done can get done in that institution.
I'm going to, at the risk of abusing the privilege of the chair, I have one more question, and that's just to see, Mary, if you had any response to Mike, because I think he was suggesting that, in fact, things aren't so bad as you're saying, that McConnell has things pretty well in hand. So I don't know if you want to elaborate a little on what you meant in your opening remarks.
Well, I mean, for one thing, I was speaking more broadly about the use of domestic information for intelligence, not just about the domestic surveillance program or terrorist surveillance program. I don't know that. I mean, I'm not familiar with, other than just reading the press reports about the proposals, the recent proposals on FISA. I think I would want to sort of see the whole thing before I really could have a comment about whether I think that they solve some of the problems with that program or not.
Okay, all right. Well then, do we have any questions from you all? Right here.
I have a question. Oh, sorry. Tom Houck, just a local citizen. How many hours or man hours or pages of documentation does it take to get a FISA court approval? I mean, what are we talking about? Everybody talks about a number of sign-offs, and what, does anybody know?
I think the answer is, in part, it depends. Well, if it is just a normal, not emergency, or there's not somebody really putting a lot of pressure on, it can take months. If in emergency situations, from my understanding, you can get FISA orders in hours. So there's no question in my mind that the bureaucracy about getting a FISA, going to the FISA court is broken. It's what I don't understand is why we don't hear more talk about that from the executive branch. There's a lot, I think, that can be done in terms of to fix the bureaucracy, to make the process more streamlined, without having to either ignore the law or even defy the law. I think that, and if there are specific things in the law that really throw up roadblocks to the process, then I think those specific things should be addressed. But we don't hear that much about how much of it is really an executive branch problem with not being able to streamline the process.
Just quickly on what the steps are. The idea for a FISA order gets initiated either in the course of an investigation or through some other mechanism. The documents have to be prepared by Justice Department staff attorneys. They then have to be, how complicated are they? Well,
Documents, I mean, how many pages of documents?
Well,
How many man hours or
it could be lots of different kinds of information. It could be copies of transcripts of intercepts that are already ongoing. The basic proposition is you eventually have to persuade a judge, that the FISA judge, that you have probable cause to believe, if you're going for an intercept order, that the person that you want to start intercepting is an agent of a foreign power. And so you have to present documentary evidence, and often the agent, an FBI agent with firsthand knowledge, goes with the lawyer to the FISA judge. They have to sit down and have a conversation. The judge will ask questions of the agent, will read the documentation, will ask questions about the documentation. That is, why are you drawing this conclusion from that informant? Is this informant a reliable informant? All the kinds of things you might suspect. If the answers aren't satisfactory, if the agent doesn't have personal knowledge and there's not an exigent circumstance, the judge will say, we'll get somebody here who knows the answer to that, or get me a sworn affidavit that includes the answer to that. There's an intermediate step. Prior to going to the judge, it has to be approved by a high-ranking Justice Department official. So that person either has to look at the documentation, him or herself, or have very high confidence in the people out of criminal or wherever it is, OIPR, who actually prepare the documents. In an emergency situation, as Mary said, you can prepare documentation and get it through that process in a matter of hours. I talked to one of the judges who was on the court after the World Trade Center bombing in '93, and they had orders out the door that night, within hours. Since the intelligence community and the FISA judges understand this, the best time to get information is immediately after an attack, if you haven't prevented it, because that's when there's likely to be chatter. And so the FISA judges prepare for all-nighters whenever anything happens. It's actually the chief judge who ends up doing this, the one who's in the Washington, D.C. area. So it can happen very fast, but you're essentially doing the same thing law enforcement would be doing with respect to obtaining an order in federal district court under Title III, except you're needing to make a showing about probable cause, not that a predicate crime has been committed, but that the person you want to surveil is an agent of a foreign power.
And I would just add to that to explain what I said before, that my understanding is that the real bottleneck is not the court.
Yeah.
It's getting it to the court.
DOJ approvals.
Yeah. But I think that's one of the reasons why you look at the request to go from 72 hours to a week, especially as these organizations have become more sophisticated, their chatter is more broken up. It's not that they get on the phone and, do this day after day after day, and so you have to build a case. I mean, you have to convince a judge, as they say, you have to convince them that this is an agent of enemy power, and that you have to establish a lot to do that. 72 hours may not be enough chatter, especially if you have a more sophisticated individual that is throwing his cell phone away and getting a new one the next day, et cetera. It's harder to follow him that way.
But just remember that if the Attorney General makes the determination that the surveillance should begin on the basis of the emergency authority, he may begin it at that moment. And he has the 72 hours to prepare the paperwork. The request is to go to a week. So it's not to delay the authorization. He makes it himself in those circumstances.
Do any of you know at this point what's the bottom line on the results here? How many indictments, how many convictions to this point in time? And sort of a second question, can any of you comment on the degree to which these data, the information is being shared with other intelligence and security agencies? We missed a lot before 9/11. I read some places that improvement in sharing of data among the agencies is not happening. Is that happening here?
I'll touch on the second one if someone else wants to take the first one. But with regard to the second, prior to 9/11, the Church Commission in the late 70s had basically put up walls or said that there must be no discussion between CIA, FBI, the various agencies, because of abuses that had occurred between foreign intelligence gathering and domestic intelligence gathering. I think that it is a hangover from that you still have this sense of, we don't do domestic intelligence if you were at NSA. They don't consider intercepts in the United States of a foreign conversation to be domestic intelligence because it's basically directed at a foreign power. And that's the way they've always conducted things. But I think that you had those barriers that were up that had been, perhaps even more strictly enforced in the 80s and 90s. And once 9/11 happened, that was one of the first things they did, was take those barriers down so that CIA and NSA and FBI and local law enforcement can all exchange information. With regard to indictments and all of that, I'll let them talk about that, but I would say that the goal is prevention and not prosecution, and so indictments is not necessarily the best measure of how successful we're being.
Go ahead.
I would just say on the indictments, I mean, I think, just to agree that that's not the purpose of these FISA intercepts, and I'm not sure, and I know that certainly information from these intercepts is being used in some cases, but I don't know that we, outside of the government, would have a way of knowing when and how often and how much, to what, how successfully.
Yeah, you get to see their use only when an indictment is entered and a defendant is arraigned, because that's when the government has to reveal that they intend to rely on such information. I don't know the answer to the numbers. I do know that if I was asked that question, the person I would call is in the room. Bobby, you know anything about this?
But I agree with what you said about that's not the point of the...
Yeah. There's a Bobby Chesney from Wake Forest who studies prosecutions in great detail and is always the person I seek advice on such questions. Even if he can't answer them, I know it's on a better basis of fact than I have.
And I would also say that it's a good thing that we don't have the answer to that. We can say how many warrants have gone out and this sort of thing, but the fact that we don't know how often it's being used is probably a good thing, because if we do, that information is not information that I think the public should be aware of, if at all possible. But it's also why you're not going to get good press reports behind the national security side of the debate.
Yeah, down here in front. Down.
Do you think it would be helpful if we could have a robust national debate, not about methodology or technology, but about definitions of our enemy, so as to avoid the confusion that seems to crop up between an enemy and someone who disagrees with a policy, someone who is a political opponent. Personally, that's what I find bothersome. You know, if they're spying on nuns and Quakers, it's crazy.
I'll start. I think that's a very, very good point, and obviously, it is a difficult thing to define who, from where this threat is coming, because it is not as clear a threat as we're used to in the Cold War days and with state adversaries. But part of the process of defining guidelines that I touched on briefly earlier, that need to have guidelines about what kind of information you can collect, how can you meaning the government agencies can collect, how they can, and under what circumstances they can use that information, is to try to be, the purpose of that process is to try to be much more clear about not only when you can, but when you cannot collect information and reasons for which you can't use it. So I think it's a really good point, and I think it's something that has not been pursued enough. Again, it's hard.
One thing I would say to that is that traditionally, those decisions have been left to the province of the executive in order to make those determinations as to how you define those things. And just one example was then Attorney General, future Justice Jackson, writing to President Roosevelt about the domestic investigations that he was allowed to do. You are at liberty to secure information by listening devices directed to the conversation or other communications of persons suspected of subversive activities against the government of the United States, including spies. You are requested, furthermore, to limit these investigations so conducted to a minimum and limit them insofar as possible to aliens. But clearly, Justice Jackson was saying, if you have to do this with U.S. people, it's certainly within the U.S. that you're talking about. We're going to let you decide who you think are subversive, and clearly that is a very loaded term, and it's been used in many different, both positive and negative ways. And so I think your fear is a very justified one. I don't know where the answer lies, though, because typically it's been left to the executive to determine that.
Yeah, right there. You, sir, yeah, in uniform, right?
Bev,
Bev?
in front, there you go.
Professor Lewis, you keep mentioning national security. I know that's the buzzwords that's always thrown out, but there isn't some Takfiri invasion force over the horizon that's going to come take over Washington, D.C. When the president was able to talk after September 11th, he said that freedom has been attacked, but external forces don't attack the Constitution. They attack people and property. So, and you keep talking about how there's no value in knowing these numbers. There really isn't value in debate. We do exist in a democracy, supposedly, and it seems to me that has some value. I mean, we may not be more safe from this because we have no quantitative way of knowing if it's making us safer, but it seems readily apparent we're not more free because it's chilling political discussion amongst electronic forums. The average American doesn't know whether or not they can put anything in an email to somebody else and wonder whether or not it means they're not going to be able to get on a plane the next time. So if all that's important is protecting ourselves, protecting our physical existence, why don't we apply this to domestic crime also? Because more people are going to be killed in domestic crimes. If it's so critical, why don't we change the Constitution?
Well, I would think that one of the things we're looking at, you're absolutely right, that domestic crime is going to cost far more lives. I think one of the ways that you differentiate this is perhaps the magnitude of an individual domestic criminal and the harm that he or she is likely to do, as opposed to the individual terrorist and the harm that he or she is likely to do. We had 15 people kill 3,000. And so that's a pretty good ratio, and clearly they can achieve that sort of thing and are looking to achieve that sort of thing again. Plus, they have access to a lot more sophisticated things. You see them using chlorine gas in Iraq now. That's not hard to make, and you could see them using that in subway systems or other things like that. So there are a variety of reasons to think that the cost to American lives and American property is going to be much greater for each attack, and so I think that's why perhaps limiting it to the foreign surveillance makes some sense. Plus, traditionally, I guess the other thing you tie that to is the Constitution has always allowed, I mean, I just mentioned what Jackson said, the Constitution has always allowed the executive to do that sort of thing. Congress has cabined that somewhat. If the executive has stepped beyond that, you do begin to have a constitutional crisis situation because you need the executive and the legislative branch working together. But I don't think that you need to change the Constitution to say that the president is allowed to do these things. What you need to do is change the law or not change the law, and then make sure the president follows it. And I think that's as far as that needs to go. I understand the concerns about, you know, chilling chat room conversation, and I don't know how much of that is going on either. On the one hand, we don't know how many terrorists we are preventing or capturing or whatever else as a result of this. I also don't know how much free speech is actually being chilled. I don't know how many people actually don't email friends overseas because they're worried about not being able to get on a plane. But I'm sure it's happening. I just don't know what the magnitude of that is, just like we don't know what the magnitude of the effectiveness of the programs are. What I do think is important, and I don't want to make give the impression that I think there's no value to tracking the numbers. I think it's good that we know FISA warrants have increased 500% or whatever since 9/11, and that the court is more active, that hopefully congressional oversight, once we establish how that's going to work, would also be able to report on activity levels, if perhaps not on the details.
But what I'm wondering is, it's a balancing test, as Mr. Schroeder said several times.
Right.
If the American people don't know what's on this side, how can they balance it against what's on the other side?
I guess my problem is that the American people will never know what's on the other side either. I mean, you can tell them what we are doing and how we're doing it in great detail because we can do that. You're still not going to tell them in great detail the attacks we have thwarted, the people we've captured, et cetera. That's just not going to happen if you care about operational security. And so if we're going to say we're going to have an open debate, the more open it is, the more tilted against the national security and national security, personal protection. I don't know how you want to describe it, because you're right. The Kafiris are not going to be in, you know, Washington tomorrow, and they're not going to take over our government or change our way of life. They're just going to kill some of us, should they be allowed to do so.
But it sounds like you're ratifying the trust us thing that you seem to objectively say it wasn't exactly that.
Well, I don't think I'm ratifying the trust us. I'm saying let us create a form of oversight that we believe is more reliable. If you can point to 10 men or 12 men and women on the Hill and say, if they say, you know, 6 from each party, so it doesn't matter who's in the White House, if they say Bush or Clinton or whoever is playing straight, I'm going to trust what McCain and Feingold together come up with, or Schumer and whoever, you know, whoever else on the other side, you know. Whatever they come up with, if they both agree, I'm inclined to think, all right, I'll feel that they are protecting my rights. Maybe most of us don't believe that. Maybe we think that we really need all 535 talking. If that's the case, we just have to be very aware of the price we're paying. We may be paying for it. I know it's going to affect surveillance. I don't know how much it's going to affect surveillance.
Robbie? Oh, sorry, I thought you had your hand up. Yeah, Steve.
Thank you. I'm Ian Goddard, I'm also a local citizen. And I don't know much about what I'm talking about. My background is engineering. However, we alluded earlier to the Ultra program during the Second World War, and that saved hundreds of thousands of lives, and some of that was directed at domestic surveillance within England and the USA, and it did save hundreds of thousands of lives. Churchill said at the time that some secrets are so precious that they require a bodyguard of liars to protect them, and I think he was right on the money. Furthermore, if you really have any doubts about the need for unfettered domestic intelligence, you really need to watch Fox's 24, and you'll get a point of poor old Jack Bauer has to put up with all the time. I mean, he's saved our lives many times. And I guess I need to ask a question just to make this legitimate.
It seems to me, and as far as I know, the United States is one of the only countries that has this type of domestic intelligence surveillance problem that we have. I don't know of any other country that has laws that prohibit the gathering of domestic intelligence. Am I correct?
I don't know the answer, but I would say we're the only ones with our Constitution also. So, I mean, it really is, and I don't mean to be flip, but that's, comparing our system to other systems is never going to be exact.
Speak more loudly.
I'm done.
Yes, Steve Dykes.
Thank you. I have a technology question. I wonder if members of the panel could comment on the pending or prospective reforms to FISA, and in particular, speculate about how it might be possible to reconcile the sort of targeted, individualized findings that the FISC judges now have to make, as Chris suggested, and with the sort of drift net program that many suspect the NSA is engaged in now. Can those things be reconciled? And if not, should we move in the direction somehow toward the drift net, and can we do that consistent with the Fourth Amendment?
I don't think the connection can be made under the present law. As summarized by Michael earlier, the apparent content of the proposal by D&I McConnell is to change a definition to allow some of the surveillance to be extended to those who are not United States persons. So the sharp line might be made in the proposal between U.S. persons and everyone else, and U.S. persons would not be amenable to a drift net or data mining kind of approach, but anybody else might be, even inside the United States. That's one approach, and I don't know that that's consistent with the Fourth Amendment. My gut tells me not. The only exception to the Fourth Amendment that's been applied in doctrinal terms is one called special needs. Special needs has been one that's been applied to, say, sustain drunk driving checkpoints on the highways or locker searches in the middle school for drugs. But it's not been used to sustain something that would be as discretionary as the program that General Hayden described, or as intrusive.
I don't know if you can match up the Fourth Amendment to what I'm speculating that NSA wants to do, but you do have to distinguish between different kinds of data mining.
Yeah.
One of the things that apparently was occurring, and I'm making all of this up on the basis of what newspapers have reported, because on the data mining side, the administration hasn't admitted anything. They've admitted that they're conducting some intercepts that would be covered by FISA if they met the other statutory definitions, but they haven't explained what they're doing on the data mining side. But it would appear that one thing they're doing is identifying a phone number where a suspicious call has emanated, and then using the telephone records of the telecom companies in the United States that agreed to cooperate to reconstruct the social network of that individual, and to see by connecting other dots whether that gives them sufficient justification then to want to be looking at particular endpoints in the United States, where I guess they may have concluded that on the basis of that amount of knowledge, they wouldn't be able to go to the FISA court yet and get an intercept order for the domestic phone call, and yet they've got some suspicion now because they've connected this suspicious location overseas where an Al-Qaeda operative has made a phone call, and that person's social network leads them to someplace in Cincinnati. That data mining, I don't think, runs afoul of the Fourth Amendment yet, because those kind of telephone records, the court has held, don't have with them a reasonable expectation of privacy, and so you wouldn't need a probable cause-based warrant to to access them. Now, there are privacy statutes that the government may be violating, but there's not a Fourth Amendment problem, I don't think. It's when you want to actually intercept a contemporaneous communication and get the content of that communication where you have a problem. Now, that's the second kind of data mining that may or may not be going on, this sweeping up of comms and using some kind of computer technology to look for keywords, the things that Hayden says is not going on, or is not the only thing that's going on. So some of that might be going on, but the only way you can get that information in the first place is to intercept the communication and then give it to the computer. It might be that if you had a sufficiently guarded procedure for dumping all those gigabytes of data into a computer analysis, and you could convince the court that you weren't retaining anything else than the ones that had been positive hits, and you could justify going after those positive hits on the basis of still what's pretty speculative information, but now you've got several dots that you've connected and you want to go after that individual. I don't know whether that might pass Fourth Amendment muster. I just don't know. But I think it would depend, at least if I were looking at this case from the department's point of view, I would want to build into that program from the administrator's side as many demonstrable safeguards as I could, so I could point to the justices and say, this is a massive search at step one, but no human being ever has the ability to overhear a telephone conversation unless there's been a positive hit. And here's why we think the positive hit raises the odds that this is a suspicious phone call by a sufficient amount for us to go in and look at just it. And everything else goes in the garbage can, in the trash can. That's a much more defensible program to me than one in which it's all kind of loosey-goosey, and you've got, this gets back to Mary's point, I think, that there are actually some good legal reasons, I think, to have safeguards in place, because it does make your program more defensible in the end. I don't know whether that would satisfy the Fourth Amendment, even as I've tried to construct it, but it would be closer to the line, I think, than a lot of people I think have just sort of dismissed the proposition that these programs might be Fourth Amendment defensible. I don't think special needs works. You'd have to have it be some suspicion-based investigation, but you just might be able to rationalize it if it were carefully controlled, so that you were doing what it's termed minimization, getting rid of all of the information that is not germane to the investigation. If you could show you really had good minimization procedures, maybe.
But if you take care of minimization, it sounded like what you backed into a moment ago was, in effect, a reasonable suspicion standard.
Yeah, I think so.
The other thing worth mentioning is that's the other thing the DNI asked for, was an elimination of liability for any of the phone companies that are participating or cooperating with NSA, because there are lawsuits out there now claiming that Verizon gave away my information and I didn't want that to happen. And so that's one of the other things that he's come forward and asked for, is a limitation or elimination of liability for the phone company cooperating with NSA.
Yeah, Robbie?
Are there any statistics or information available either through data banks or reports indicating the number or the percentage, rather, of requests to the FISA court that are turned down? How many don't get accepted or rejected?
There's only been one in 29 years. You get a biannual report now on the Department of Justice webpage. A couple of clicks, you can get it. It used to be an annual report, now it's biannual, and there's a little more detail breaking down the types of requests: national security letters, business records, electronic surveillance, and so on. But the success rate is one that you would aspire to.
We've been talking about the use of tapping phones and emails. My question refers to the emerging technologies. You have voice over internet phones and webcams. Should they require a warrant for those when, an average college student like myself could hack in very easily in 30 minutes? Do you require a FISA warrant to go into information like that when it is a private conversation, but it's streaming open over the internet?
Well, I'm pretty sure they're covered by a combination of Title III's restriction on law enforcement and FISA. FISA is not limited to any particular technological form of communication.
It's just electronic surveillance, right?
Yeah,
That's
electronic
the term.
surveillance, which I think
Electronic
comes
surveillance would certainly include.
I think
Yeah,
it would.
I would think so.
And
Definition is very broad. It's 30 years old. So nobody was thinking of VoIP, but the language captures it.
And as to it being easy for a private citizen, so why shouldn't it be easy for the government? Well, the Fourth Amendment's a constraint on the use of government power and authority. There are lots of, you can go up to Radio Shack and get a scanner and dip into people's cell phone conversations pretty easily too. But the government can't do that without a warrant. So it's not the technological complication, it's the notion that this is a restraint that we're putting on the use of government authority to invade somebody else's private communications that is the real legal obstacle.
We have time for one more. Yeah, right here, right in front of the microphone.
I'm inclined to be hopeful that in the coming year we'll have increased cooperation between the executive and the legislative because of the different political climate that we're in today as compared to December of 2005. And I was wondering if any of you could comment on that, on my sort of hopeful attitude that the executive branch is going to be pressured to release more information and to cooperate a bit more regarding the program.
I hope you're right. I'm just about to go up and work on the Hill on these issues. So I think that that we're seeing more interaction on some of these issues, more discussion, certainly with the new proposals that have gone up to the Hill on FISA. As I said, I'm not commenting specifically on any of them, but I mean, I think it does suggest that there is more of a inclination to have a discussion and with the Congress about these issues. So I guess I share your optimism, but I don't know that I have anything more than a sense.
My one concern about that would be, unfortunately, as our election cycle has extended and extended, and we are already trying to pick our next president a year and a half or more out, it feels like the positions that the main contenders are going to be taking are going to have as much to do with this, unfortunately, as perhaps the position that the current executive's taking. And I don't know if that's going to be a problem or not, but I think it is an unfortunate thing that our election cycle now begins the moment after the midterm congressional elections, because I really think that it does cause some difficulties for the final 2 years of presidency.
Yeah, I agree with all of that too. I remain an optimist about these topics. Part of that's because I think we're just coming out of a very dark period. If it's down from here, we're in the soup. So it's got to be up from here. And I do think I see some encouraging signs on some fronts. It's not going to be easy because of the political overlay and the continual campaign that has invaded the dealings between the two bodies. Seems to be constantly there. But I think there are some positive signs. I think Leahy's conducting himself reasonably well in judiciary. I think that Waxman's showing that he's going to be tenacious but is trying to be disciplined at the same time. And at least the Democratic leaders are saying the right kind of things, that they don't want to politicize these issues and they don't want show trials. They don't want to start gotcha oversight hearings where the main function is to abuse somebody in public instead of trying to be constructive about the programs. It's still going to be very contentious, but I have to think that I have to agree with some of your optimism.
I'm going to go ahead and take the liberty of saying that I think this has been yet another panel that has added to the debate, informed the debate, and will you join me in thanking Neil and the panelists? when we put these conferences together, we try not to exhaust you by having too much in the day, so 3 panels and the Prince at lunch. Now we're going to give you a little bit of a break. For those of you attending the dinner tonight at 7